Walter. I just wanted to take a second to thank you all for joining us for the first installment of our Emerging Risks virtual conference. In different times, we would all be in the same room, enjoying coffee and conversation. Instead, we find ourselves at home in our Zoom shirts, wondering about whether our kids will interrupt us in the most inopportune moments. And if history is any guide, that will certainly be the case. Despite the circumstances, we really appreciate you all engaging on this critical topic, looking at the emerging risks in student financing. I want to first thank our keynote speaker today, Oregon Attorney General Ellen Rosenblum. She has been an incredible leader and partner on so many issues that affect student loan borrowers. A few years ago, back when I was still at the CFPB, General Rosenblum hosted her first conference on student debt and consumer protection in Portland, bringing together the law enforcement community and leading experts to discuss the enormous challenges facing students, borrowers, and their families. Last year, our organization was honored to co-host a follow-on event with the Oregon Department of Justice, looking at the ways the student debt crisis has changed in the intervening years. In so many ways, today's panel builds on the foundation AG Rosenblum has built. It's no secret that we are facing a student debt crisis. 45 million Americans collectively owe $1.7 trillion in student debt. And this was before the fallout from the pandemic. Now, laid upon the existing crisis are tens of millions of Americans out of work and countless others' financial lives in turmoil. An economic crisis that may take decades to recover from. But in one corner of the student finance market, a new financial product, income share agreements, has emerged. Schools have partnered with financial firms to offer ISAs as an option for students to finance their education. These products are often touted as a solution to the student debt crisis, despite creating financial obligations that often exceed the cost of traditional student loans. In design, these products mirror many of the most common features of loans. They cover a set amount of tuition, and borrowers don't have to worry about repaying until down the road. In every sense, these products are an extension of credit. But proponents of ISAs repeatedly argue differently, saying that ISAs are something else, that they need to be treated as a unique product, or that they need regulatory clarity. Today, we are kicking off our conference series to dig beyond the catchy slogans and marketing materials. Over the next 3 weeks, we will be diving into the details of ISAs, looking at federal and state consumer protection laws and why and how these laws apply to income share agreements as currently designed. In conjunction with this conference series, we are releasing papers before each panel, authored by some of the foremost experts on consumer protection. If you hadn't had a chance to read the first paper, which is up on the Emerging Risk website, I strongly encourage you to do so. Again, today's panel will look into how credit is defined, why ISAs are credit and therefore subject to a number of federal statutes regulating credit. On July 30th, we will talk about the fair lending risks associated with ISAs. And then finally, on August 6th, we will discuss state consumer protection law implications on ISAs. Taken together, we hope that this will provide all stakeholders, lawmakers, regulators, enforcement officials, industry, investors, and borrowers, the clearest picture of what the law demands of ISAs and the minimum protections that all borrowers must receive. I now want to turn to video remarks provided by our keynote speaker, Oregon Attorney General and good friend, Ellen Rosenblum.
Welcome to Emerging Risks, a virtual conference on income share agreements. Before I begin my remarks, I want to thank the Student Borrower Protection Center, especially Mike Pierce, for inviting me to speak to you today. America is facing a student debt crisis. More than 45 million Americans now owe $1.7 trillion in student debt. We spend a lot of time focused on the big chunk of this pie that is owned or backed by the federal government, federal student loans. These loans place a major burden on tens of millions of Americans' financial lives. It has been my long-running priority to tackle the widespread consumer protection challenges these loans create for consumers, cracking down on predatory student loan companies and for-profit colleges, and standing up to the Trump administration and Betsy DeVos. Today, I want to focus on a slice of the student loan market that gets less attention and the risks these financial products pose to students and families. We've worked hard to protect borrowers with traditional private student loans and other kinds of private credit. My office led the fight for justice for the students who attended schools owned by Corinthian colleges and who were pushed into predatory private student loans. When we took action against the private equity firm Equitas for its role in this scheme, we made it clear that it is never acceptable for big financial interests to exploit students. That experience is part of why I'm happy to be here today to talk about emerging risks to students and families as they pay for college, specifically a new form of financing known as income share agreements. Income share agreements, as you will hear from our panelists today, are touted by their proponents as a silver bullet to solve the student debt crisis. Income share agreements, also known as ISAs, require students to pledge a portion of their future income in exchange for money to pay for college. Although these products mirror student loans in most respects, many ISA backers claim that these financial products are not credit or debt and therefore should not be subject to common consumer financial protections. That claim is a red flag for regulators and law enforcement officials, and it should also drive students and families to use caution. The pandemic has made it even harder for some families to pay for college. I am concerned that in this environment, students and families will be more willing to try complex and risky financial products that may not be in their best interest. As Attorney General, I'm particularly concerned about deceptive marketing practices. Students have a right to truthful and accurate information about ISAs, and the terms and the risks should be clearly disclosed and explained in language anyone can understand. Policymakers must weigh the benefits of this new type of funding with the risks to young people who may not understand what they are signing up for. Schools also have a role to play. If schools are going to partner with ISA providers, then schools must ensure that their students have all the information they need to make informed decisions and to evaluate other options. We are still dealing with the fallout from failed for-profit schools that preyed on unsuspecting students. I do not want to see the same thing happen again. We must continue to be vigilant and monitor emerging risks to students and families. And we must ensure that companies offering income share agreements and other innovative financial products for students follow the law. I look forward to hearing more from all of the great panelists about these issues and what we can do to better protect our students and families from emerging risks in this area. Thank you for taking the time to join this important conversation.
I would now like to introduce our moderator for today, Washington Post reporter Danielle Douglas-Gabrielle.
Thank you, Walter. Hi, everyone. Thanks so much for joining us. So a little background, income share agreements have been around in one form or another for decades. Economist Milton Friedman proposed the idea in the 1950s, and a handful of Latin American countries have been using the agreements for decades. Yet ISAs have been slow to catch on in the United States until recently, as venture capitalists have shown interest, and Purdue University introduced its own program in 2016. A number of small companies and nonprofits have piloted programs or offered contracts, with the model gaining the most traction with short-term training programs. The legal and regulatory framework for income shares remains a bit nebulous. Income shares operate like traditional loans in that students are obligated to repay at least a portion of the money they receive, but unlike with a student loan, no interest accrues. Some people are excited about the potential of these agreements, and others are concerned about the risk to students. Consumer advocates say clearly defining income shares as credit could mitigate some of those concerns, as existing regulation would apply. But some proponents of ISAs have argued they are fundamentally different from loans and should not be regulated as such. With us today to delve into the question of whether ISAs can be considered credit are Joanna Pearl, the former Enforcement Chief of Staff and Acting Principal Deputy Enforcement Director for the Consumer Financial Protection Bureau, and Brian Scherer, the Legal Director of the nonprofit Justice Catalyst Law. Joanna and Brian are going to give us an overview of their new paper on how federal consumer financial law governs income shares. Joanna will kick us off.
Thank you, Danielle. And thank you to the Student Borrower Protection Center team for the invitation to be part of this conversation. I'm excited to discuss this important topic with Danielle and this impressive group of panelists. I will give a brief overview of the paper that Brian and I recently wrote on this topic, and then I will turn it over to Brian to summarize our analysis. As Seth and Danielle just noted, ISA lenders say that their agreements are not subject to existing federal consumer protection law because they, unlike traditional student lenders, do not extend credit. Our paper takes on that contention and comes to the opposite conclusion. We explain why ISAs are credit under existing federal consumer financial law, and therefore why these products are subject to the requirements of these critical consumer protection statutes right now. I wanted to just say a little bit about our approach to the paper and the analysis. We thought about this issue in the same way we approached consumer financial products when we were enforcers at the CFPB. We started by looking at how ISAs work, and the student borrower experience with them, and in particular, the places where there's potential for consumer harm as consumers and students interact with these products. So our paper puts ISAs in context, and it gives an overview of the key features of income share agreements. As I think we'll end up discussing today, the terms of ISAs vary across institutions and programs, but there is a shared vocabulary and structure, so we present that. We also explain how ISAs are functionally equivalent to traditional student loans with income-driven repayment options. And then we turn to look closely at what the law requires. We came to this exercise with an open mind, and our paper is the result of where we believe the application of the law inevitably leads. As most folks in this audience and in this conversation know, many of the requirements of federal consumer financial law apply to credit. And so the core question we addressed is, are ISAs credit? And we answer that question in the affirmative for the following statutes, most of which are remedial statutes that are read liberally to protect consumers. So we look at the Equal Credit Opportunity Act, the Fair Credit Reporting Act, the Truth in Lending Act, and the Consumer Financial Protection Act of 2010. We also discuss the Fair Debt Collection Practices Act, which doesn't require credit for its application, but which does define debt and is therefore instructive in the overall analysis. So having set that stage, I will turn it to Brian to tell you what we found.
Thanks, Joanna. So in the paper that we just released, we methodically walked through each of the statutes that Joanna just mentioned and determined that ISAs and ISA lenders meet the criteria for those laws applying to them. And at a high level, the ACOA, FCRA, the CFPA, and TILA generally have very similar definitions of credit. They differ a little bit, but they're quite similar. And generally speaking, credit arises when either a party grants another the right to purchase a service and defer payment for that service, or a party grants another the right to defer payment of a debt. So it can meet either of those criteria, and the laws apply, except TILA, which only has that last definition. And there are a lot of additional subtleties. This is an extremely broad brush that I'm painting with right now. And to get into those weeds, you can take a look at our almost 30-page paper. So we concluded that ISAs meet both definitions of credit. For the first one, ISAs give student borrowers the right to purchase educational services and defer payment until after they graduate. And that's all you need for the ECOA, for FICRA, for the Consumer Financial Protection Act. In addition, we think it also fits the second definition because an ISA grants consumers the right to defer payment on a debt. And importantly, we dug into the definition of debt under those statutes, and many of them don't have a definition of debt. And so we borrowed from a lot of different places. The FDCPA has a definition, the Bankruptcy Code, there are many legal dictionaries and state laws. And we concluded that under all of them, an ISA does create a debt. And so the implications of this is that these laws apply as written now to ISAs. And so ISAs should be following them, or else they are going to subject themselves to very significant liability, up to about $6,000 to over $1 million per day in civil money penalties can be charged against a company that violates these laws. And there are other very significant remedies that they can be subjected to. And given the importance of these protections, we think that they should be applied to ISAs to protect consumers in the ways that the laws were intended to.
So guys, we're gonna open the panel up a bit. We're gonna kick the first question off to Kevin. Kevin, do me a favor, and I ask this of all of our panelists, introduce yourself first and tell the audience a little bit about yourself before providing an answer. But question to you, Kevin, is what are your thoughts about the role of existing consumer protection laws as it pertains to ISAs?
Yeah, sure. Thanks, Danielle. Well, just to give background, my name's Kevin James. I'm the founder and CEO of Better Future Forward. We're a 501c3 nonprofit, and I founded BFF to try and create a financing alternative to private loans or simply working too much with a focus on low-income students to help them have accessible, protective, and sustainable funding options that would help them persist in graduating college and make a strong transition to career. And so that's been the focus of our work. And so, yeah, to get to your question, Danielle, I think about this in two levels, this question about consumer protections and existing consumer protection frameworks and ISAs. The first is sort of a legal level, which is how do ISAs fit within the existing regulatory regime as the laws are written? And I think Joanna and Brian have added, their paper adds a lot of valuable perspective to that question. And for the purposes of my participation, not being an attorney, I think that's something better left to legal experts. But I think there's a closely related question that's really valuable here, which is the policy perspective. And within that context, I'd say, I think the existing framework of consumer protections ought to be applied to ISAs, but with some amendments to make sure that we're actually achieving the protections that those laws were intended to effectuate, given the differences between ISAs as an income-based tool and sort of traditional fixed payments loans, which a lot of those laws were primarily written for. The other thing I'd add is that I actually think we need to go farther. So I think in addition to applying existing consumer protection frameworks in the right ways to ISAs, I actually think we need to add new protections that have never been in the law. So for example, caps on the percentage of income that can be committed. There's nothing that prevents a private loan from consuming huge fractions of your income, a threshold under which you have no obligation. There's nothing that says in law that you have to have no payments on a private loan when you're earning below a certain amount, a maximum duration regardless of how much you pay, a definition of income that says, there's nothing that says in law that a private loan can't consume all sorts of your income because you're on the hook to pay it no matter what. And so I think we need to incorporate existing law and apply a higher standard than what would be applied by existing law. So let me just pause for a second just to give some context for why I come to this answer. I left the policy world and I founded BFF because I felt like the ways in which the civic and market sectors have been able to participate in the critical mission of helping students achieve post-secondary education has been severely limited and in many ways problematic, as expressed by private loans and the fact that they're typically inaccessible and not protective. And so I was drawn, initially my work was on IBR in the federal programs and how to make IBR more streamlined and simple. And I was drawn to the question of how we could create sort of a complementary role for private markets that would be much stronger and much more constructive and built around these principles. We think of them like a triangle of access, protection, and scale. Something that is truly accessible to students based on what the fact that they're making a good investment in their education, something that's protective and actually transfers financial risk off of students, and something that's sustainable based on their outcomes. And I was drawn to ISAs as a tool that could do that if done well. And the thing is, obviously, and we wouldn't be having this discussion, ISAs are just a tool. They can be done badly and they can be done well. And so bringing this back around to the regulatory point again, I think we both need to apply existing law in a way that is adapted to the unique needs of ISAs, but also create new protections that actually effectuate those principles in the way existing law has not. Because existing law has allowed the private loans that we know have tended to be very abusive to thrive. And so I think we need to take that step of adding additional protections. And I hope, again, I appreciate the opportunity to be here, and I know we're all working towards the same basic end. And so I hope we can achieve that by continued conversations like this.
Thank you, Kevin. Jessica, over to you. So supporters of ISAs often talk about how they are new financial products, that they may need time to develop, and that they need legal clarity. What role do states and state law enforcement play in this space?
Sure. First, thank you. Thanks for being on the panel. It's an honor to be with these panelists. My name is Jessica Whitney. I am the Director of Consumer Protection for the Iowa Attorney General's Office. In that role, I'm also the administrator of the Iowa Consumer Credit Code, so it serves sort of a dual function of enforcement and regulatory function. In Iowa, we've taken the tack that everything old is new again with respect to ISAs, and that while it's perhaps a new idea of a product, but it's a new idea on an old tune. It is something that we feel fits under our existing laws, not only our credit laws, but we have a wage assignment provision. And we feel it's just a new way of wage assignment, and that our sort of broad consumer protection laws have been designed to allow things to evolve and expand and still cover things like ISAs. We do feel their credit. We do feel their wage assignments. The role states can play is they can take their existing laws. They are traditionally the regulators in this credit space, excluding, of course, federal student loans, but they are traditionally the regulators that look at the extension of credit, especially by non-depository national banks, not national banks. And states play that laboratory of democracy role. They are the chance to get an up close and personal look at how these ISAs are operating, and able to protect their citizens in a manner which they see fit. If they feel like their existing laws don't cover it already, and they can take a look at that, it's a place where they can more quickly, perhaps, than the federal government go and act to perhaps put in some of those protections and the guidance that they need to make sure their students are safe in this atmosphere where we see student debt just careening out of control. This is states serve as that sort of immediate protection because they can act quicker, and a lot of, again, existing state laws are already in there and are already designed to protect consumers from bad practices by ISAs or exorbitant interest rates or payback amounts. The protections are there. Like I said, in Iowa, we found them to be credit and wage assignments. We found them very similar to lawsuit loans, where you have this promise, you get this money and you only have to repay it upon X thing happening. You get a job, you win a lawsuit. But we find lots of underwriting done. We find it's still debt and we find it's still credit. But again, at the end of the day, states serve that sort of, let's look at and see what's going on, and let's protect our students, and let's do it in a quick manner. And if the federal folks want to come in at the end of the day, they can see what all the states have done and they can see what has worked and maybe what hasn't.
Thank you, Jessica. Turning over to Josh. Josh, how do ISAs fit in the existing framework of education financing, and could they be a part of the solution for addressing rising student debt levels?
Thank you, Danielle. Good to be here. I'm Josh. I am Senior Policy Advisor for Senator Elizabeth Warren, where I handle all education policy, including student loan policy. And to your question about could ISAs be a solution to the crisis that's facing students and families, the affordability crisis, the student loan crisis, my answer to that would be no. And I think that comes down to how you define what the crisis is, and the way that we define what the crisis is, and the way that Senator Warren defines what the crisis is the fact that the vast majority of students in this country, and a disproportionate number of students of color, low-income students, first-gen students, absolutely must obtain some form of higher education financing to achieve a college degree. The thing that we have all agreed is the clearest, most viable path to a middle-class lifestyle, to economic mobility, to financial stability. We have a system that, to be clear, is a policy choice that disproportionately means that certain segments of the population, those who the system ostensibly is most designed to help, have to go into debt. And as an outgrowth of that, the outcome being that student loan outcomes are highly racialized across any outcome metric that you could come up with. You see disproportionate outcomes for Black and brown students. That is how we define the current crisis, the current affordability crisis, the current student loan crisis. And a financial product, a new form of loan, is never, in our view, going to be a solution to that crisis, because that crisis is so wide, so deep, and is a crisis of policy failure. This stems from a policy failure. Now, I think to come at the question from a different direction, I think that the way that people, when folks talk about it being a solution to the crisis, I think what they mean is that it is a preferable alternative in the current system we have to other forms of financing. And in answer to that question, is an ISA a preferable form of financing within the current system we have that is an outgrowth of the crisis? I think the answer is it depends. It depends on the particular student. It depends on the particular circumstance of that student. It depends on the terms of the ISA more than anything else. ISA, Senator Warren, coming from a law professor background, likes to talk about ISAs as just another form of contracts, a contractual form of debt, contractual form of credit, a contractual loan obligation. And like all contracts, you can have favorable terms for consumers, you can have unfavorable terms for consumers, you can have predatory terms for consumers. And so when I think that we sort of view ISAs as a symptom of this broader illness we have, rather than a cure to the illness of higher ed affordability.
Thank you, Josh. Julie, we will take it over to you. So talk to us about the marketing of ISAs, and what impact do you think that is having on the regulation of this particular product?
Sure. Hi, thanks for having me, you guys. I'm Julie Morgan. I'm the Vice President of Research at the Roosevelt Institute, and I've been researching ISAs for quite a while at Roosevelt. But I also worked on the Hill. I worked with Josh in Senator Warren's office, and you know, this panel is taking me back to the fact that one of the early projects that we worked on together there was me talking to Kevin about ISAs when he was working for Congressman Petri. So we've all been at this for quite a while together, puzzling through how to think about ISAs more broadly, and then particularly how to think about regulating them. And you'll see in everything from the way that ISAs are described in kind of like popular media, in the New York Times, or in columns by ISA proponents, to the, actually the way the website for like Purdue's Backup Boiler talks about ISAs. They say upfront, this is not a loan, right? And that is both meant to confer some sort of legal definition, but also it's a marketing tactic, right? So, and we know for students that can be very appealing and reassuring that they're signing up for something that's not a loan. It draws the borrower's attention to the fact that the payment obligation is different, and so it's obviously an effective marketing technique there. It's also an effective marketing technique to policymakers. We've seen a lot of policymakers who are very interested in finding a way to solve, as Josh noted, we have a huge affordability crisis for college. We have a student loan crisis, and policymakers are drawn to the idea of trying to solve that without having to get into the very real political problems of figuring out how to pay for things, right? So wouldn't it be great if someone came to you with a way for you to say, I have a solution to the higher education crisis, affordability crisis, that is not going to add to people's debt burden, and that is bipartisan, and that won't cost taxpayers a dime. Like that would be a wonderful thing if we could get there. Just to be clear, from the Roosevelt Institute's perspective, solving our affordability crisis is going to require like pretty substantial government investment. But I think it's important to recognize that it's more than just a marketing tactic, right? It is the marketing of ISAs as an alternative to a loan is meant to draw in broader appeal, but it's also very clearly a tactic towards regulatory change. So that there have been a couple of ISA proponents that have been a little bit more upfront about what's happening here. They've said things like, we're trying to create an asset class here that is somewhere between a loan and an equity arrangement, and that's really telling, I think, right? This is an intentional move to create something that is appealing to investors, and that kind of like navigates the legal distinctions between credit products and other products in ways that are most favorable to investors. So there are some things that are benefits to being classified as a loan. So for example, early versions of legislation to regulate ISAs chose kind of like the best of being called a loan, which would be to be exempted from bankruptcy protections, right? That's a good thing about being a loan. They'd like to take that piece of it. But having to comply with ECOA is a real downside for investors it's an upside for consumers, a downside to investors. And so these bills sort of cherry pick the good things about being a loan and steer away from the negative things. So that sort of classification of like, well, we're not really this and we're not really that, but we're wonderful, is part of a larger scheme to create a market for this product that is that draws investors in and that draws students in as well.
Thank you, Julie. So we're going to open it up to all of our panelists. So feel free to jump in with if you have an answer to any of these questions. And we also ask the audience to feel free to submit questions if you would like to find out more from any of our panelists joining us today. So is there something inherent about an ISA, either as an individual product or when you take the business model to scale, that makes it incompatible with the following the requirements of statutes highlighted in Joanna and Brian's research?
And I'll jump in if that's okay.
Sure.
Yeah, I think these have been great comments, and you're right, Julie. You and Josh and I, we definitely worked on this for a long time, and to respond to a few things that you guys said, Josh, I totally agree that I don't think ISAs can be a solution to all of this. I think the solution is a multifaceted set of policy changes in a complex higher ed system, of which government must be central in terms of its role in promoting equity. I think that is absolutely true. And I think the proper way to think about the role of ISAs, at least from my perspective, is given the importance of advancing educational equity, as to me, one of the defining challenges of our time, what in what ways can we harness the vast sort of civic and market assets that the U.S. has at its disposal to create well-structured programs that complement government, what government can do to address the gaps that we see with dreamers and insufficient aid and innovative programs. And so I totally agree with you in that regard. And so I think what I'm interested in is that I feel, just based on working on this for a long time and talking to some of you for a long time, that there's actually more overlap here than what the debate or discussion might reveal, in the sense that assuming that you think income-based options are better than private student loans, for example, as a more constructive way to protect students, which I certainly do. The question is, can we put policy changes in place that actually bring about a better student financing market than what we have now? And that's where I think there's a lot of possible agreement, because again, I think both that the existing framework of consumer protections should apply. And so, for example, if you look at the recent iterations of the federal bill, they do apply ACOA, they apply FDCPA, they apply FCRA, they apply EFTA, they apply CFPB as the regulator. So I think there's an expression there of a desire to apply those laws, and certain ones are amended. So for example, ACOA is amended in one particular way that I think is worth discussing on the later fair lending panel. FCRA around credit reporting is amended to address the unique aspects of reporting under income-based obligation. So what I'm trying to say is I think there's actually a lot of broad agreement that these frameworks should apply. And really a lot of the discussion should be, in my opinion, around how exactly to do that correctly. And in addition, I think where the most agreement can be is that we need more protections than what existing law provides. One is that the most recent iterations of the bill would provide the lower discharge standard for ISAs, a lower standard than what's provided for private loans. But also, again, the protections that I cited earlier, like a cap on the percentage of income, a cap on the duration of the contract, none of these things exist in current law. And I think it would be an opportunity to put something in place that's much stronger. And so I sort of express a strong desire and to want to work with you guys to craft something better than what would be in place in current law.
Joanna, would you like to follow up?
I would, yeah, and I'd be interested in hearing what Joshua and others' perspective who may be also closer to the legislation than I am. I wanted to just respond to the proposed legislation, respond to the comment about what I think is the 2019 federal bill, because I think the amendments and the sort of tweaks or the things that are being sort of characterized as, just fine tuning for ISAs are actually quite significant significant things that actually undercut a lot of these consumer protections. So, for example, the proposed bill does, make ISAs subject to ACOA, but it says that making decisions about ISAs based on major or academic program are not considered discrimination, which I think this will be the topic of the next conversation. So I don't want to get ahead of our counterparts who are writing a whole paper about this, but the saying that this model isn't discrimination is basically saying it's exempt from ACOA. Similarly, the proposal says that ISAs and ISA lenders are not credit or creditors under TILA respectively, which removes all the potential TILA disclosures being a requirement. It gives certain authority to CFPB, but it doesn't give them any discretionary rulemaking authority. It just allows them to define a template disclosure and to write certain rules about how credit reporting should be done. So I think it's, and again, like I said, I'm not steeped in all the policy conversations that have gone into that bill, and I understand it's bipartisan, and I certainly agree with the comment that you made, Kevin, that that existing laws should apply and that higher standards should be applied. That sounds great, but I think that the devil is really in the details of what these proposals say. And from my perspective, I have heard the we need specific regulations for our product argument before, and I think that often is I'm not saying this is what you're saying, but that is a a way of saying, well, we don't want to have to comply with what is already on the books. And so I think that's sort of fraught as I read it.
I can add, I'd love to respond to that, but I don't want to jump in, Julie, if you wanted to add something. You were raising your hand a second ago.
Yeah, is that okay? I just wanted to say a couple of things. One of the things that is really challenging about the discussions about ISAs is that the contracts themselves are not all the same, and the people who are pushing ISAs are not all the same either. And so, there are some people like Kevin with whom we've had some really great back and forth about, good faith ways to regulate ISAs. And then there are other people who I've talked to within the industry who don't seem to be coming to this, let's just say, from a place of access and equity in higher education. And even those who have those larger goals don't really think about the field in the same way that we do. So for example, I really share Josh's concerns about the racialized nature of student debt and how ISAs layer on top of that. And I talked to a lot of ISA investors who really don't understand that, how if you take a product that is sort of like race neutral in that everyone, it pays the same rate of the same percentage of their income, and you layer it upon a labor market that we know has plenty of discrimination within it, you are creating racialized outcomes. That's not something that I don't think comes up when investors are developing these products. Let's just put it that way. So, so it does make it a little bit challenging to talk about them. But I think even where proponents of ISAs are coming to the table in good faith to think about regulating them, it takes me back to the history of other credit products where we have seen that coming to the table to create a regulatory structure for a product does not always result in less debt or safer products. And so if you think about like the history of loan sharks, right? Loan sharks it was like illegal. You had all these people operating outside of the law, and there was an effort to bring that kind of lending into a legal structure. And what happened was we ended up with like higher usury caps and more people taking on not the riskiest debt that they could have taken on, but pretty risky debt. And so I think, a lot of us are coming to the conversation here in that way, which is like, we have a regulatory structure existing that many of us believe already applies. And we know that opening up a conversation about creating a new regulatory structure is very likely, and in almost by design, is going to end up with more people borrowing. And so we need to think about that really carefully.
Kevin, did you want to follow up?
Yeah, thanks. And thank you both for those comments. I'll say a few things. One is on the, Joanna, on your comments about the legislation, I thought you'd mentioned both of those things, and I think they're both worth further discussion. So for example, on ECOA, I think the underlying motivation for that change is simply a sense that there needs to be some way to build, like in a well-structured student finance market, complementary to federal loans, there needs to be some way to build underwriting around outcomes, around the quality of institutions, the quality of programs, rather than what's been in the past, which is students' backgrounds, credit scores, things like that. And this really mirrors the evolution of what's happened in federal programs. So for example, we've seen gainful employment and other rules that are designed to try and kick out underperforming programs. And I think we want private actors to do the same things. We don't want them to come in and fund poorly performing programs. So I think the impetus is to try and figure out the right way to allow that kind of outcomes-based underwriting. And if what's in the bill is not the right way to do that, I think, speaking for myself, but I also think it's true of the people I've spoken with in the ISB, I think there'd be a lot of receptiveness to try and figure out how to do that. And maybe it's not amending ECOA at all. Maybe it's just applying ECOA as a blanket as it is. But I think that's sort of the impetus, and we would love to discuss that further. And I think it's a perfect topic for the Fair Lending panel. On TILA, I will also sort of say, just having been involved in the legislation, I don't think the intent was to carve out large portions of TILA. I think the intent was to simply say, here are the disclosures for ISAs, and we don't want you to apply sort of the loan disclosures on ISAs. I actually think there's a lot of room to have conversations about how to incorporate the rest of TILA in the right way so that it truly lives up to the principle of applying broad consumer protection frameworks, that broad consumer protection framework. So this is just, again, a way of saying just on, because I have sort of been in these conversations and mentioned at various points, I'm trying to sort of bridge what I see as miscommunications in this dialogue to say I think there's actually far more overlap than what might seem to be the case. And so finally, I want to say, I totally hear you about, you mentioned that sometimes these discussions about, oh, we need our product regulated in a different way, or we need regulatory clarity, they are efforts to see it sort of either undermine existing regulation or get lower standards in place. Now, I totally understand that concern. And more broadly, I understand the concern that, you know, the role of the private sector in higher ed has not been a great one. We've had a lot of abuses, you know, going to for-profit college and others. So I certainly think we need to bring a skeptical eye to this. But just having devoted myself to this work for years and worked and seeing the value that it brings to our students who are, you know, working a godly number of hours just trying to get through college, and having a well-structured financing option available to them makes a huge difference. And I'm sort of making an appeal to say, I really think the overlap is there. And if we can work together, I think there's actually a broad receptivity in the space to put in place something that lives up to the principle of applying the same protections and adding more. And I think if we work together, we can achieve that.
Josh, you had your hand up.
Yes, thank you. Well, first, for folks watching at home who might be a little lost, I want to situate in what the legislation that is being discussed is. This is the ISA Student Protection Act. In the Senate, it's been introduced by Senators Young and Rubio, as well as Senators Warner and Coons. So I just want to make sure that folks understood what we're talking about. I think we're a little inside the inside baseball here. So on the question of federal legislation, I think that there's the threshold question of is there a need for some additional regulatory clarity in the ISA space, which I think is largely the topic of this conversation that we're having. And my reaction to that question is it sometimes appears as though folks who are arguing that there is a need for regulatory clarity are conflating regulatory ambiguity with a lack of regulatory enforcement. And just because we haven't seen a ton of regulatory enforcement around ISAs that folks might argue are predatory does not mean that there's a lack of legal clarity in those instances. I mean, I think if that was the test since 2017, there's been a lack of a lot of enforcement across a lot of consumer products that we would argue that does not mean that the law isn't there. And I think that there's definitely, one of the things that, we're hyper aware of and thoughtful about is there the risk of creating a negative inference that with legislation that the current framework of consumer protection laws, federal laws, do not apply when you have to legislate that it does apply. And to my knowledge, I don't know that we've seen, federal judges across the country misinterpreting federal consumer protection law in its relationship to income share agreements. I think it's just too soon. We haven't seen enough action or litigation there. But then to get to Kevin's point about so once you get past that question, the next question of, is there a need to erect guardrails and protections around the types of ISAs that are allowed? And, to that question, we sort of think about it like, if you erect, guardrails around what types of contracts are allowed to exist, what is the most aggressive, predatory, wildest version of the thing that can exist within this playpen that you've erected? And once you do sort of identify that and then start to pull it in and pull it in some more, every time you pull in one of those guardrails, you're probably cutting into someone's profit that somebody would like to make off of these things, right? If you say that, well, you can't cap it here, you have to cap it here. You can't have it for this many years, you have to have it for this many years. Once you start to erect those, you start to have folks who have a financial incentive to make money off of investing in ISAs start to raise a stink and say, wait, we said we want a guardrail, but not that guardrail, right? And I think this just goes back to the point I sort of opened up with, that Kevin's right. The private sector involvement in higher education has not always been so great, and I think we would argue that's because the private sector's involvement normally stems from a financial incentive, and a financial incentive is inherently incompatible with the civil rights and equity incentive of how we think we should be thinking about higher ed from a public policy perspective.
Brian, I saw that you had your hand up. Would you like to also follow up?
Sure. I just wanted to chime in and say I agree with Josh that there is, I don't think there is actually a lot of ambiguity, and I think the argument that there is a lot of ambiguity in the law is maybe a tactic to get your foot in the door to do some legislation and get some exemptions in that legislation. I think the laws as written clearly apply to ISAs, and that there hasn't been enforcement primarily because it's still a budding market. A lot of these contracts have arbitration clauses, so there isn't a lot of private litigation, and state AGs and the CFPB just haven't gotten around to it yet, maybe for political reasons or maybe because they've got other priorities. But it's probably coming, especially if the market continues to grow. And the other thing I wanted to point out is I think that there is something about TILA specifically that makes it especially important that the same rules apply to ISAs that apply to student loans. Because if ISAs are going to be promoted as an alternative to student loans, then it is really important that consumers get the same standard disclosures so that they can compare the two and decide for themselves which to do. And that means, we shouldn't have special rules for ISAs that end up meaning that there are sort of two separate sets of TILA disclosures that don't really work together and aren't apples to apples. You need an APR disclosure for both, a finance charge disclosure for both, so that consumers can lay them side by side and make a comparison.
Just checking, does anyone have any additional follow-up? This has been a really good, lively debate thus far off of one question. So just go ahead.
Thanks, Danielle. Yeah, no, these are great comments. And let me just add a couple more thoughts from a different angle. One is, Josh, I agree with you that if we start to put in guardrails, every guardrail cuts into someone's profit at some level, or if you're a nonprofit, it's not really a profit. But and that's, our role is to put in place policy that's good for students, not to put in place policy that helps, which is, I think, your point. And I think the concern that I have, particularly being someone who is trying to build this out, I think in the right way through a nonprofit, trying to help low-income students, is I want this to work. I don't want this space to blow up. And these existing, the law does not put in place right now any of the protections that you want for income-based tools. And so sort of taking the stance that we just want to sort of rely on existing law to provide these protections, I think is highly inadequate. It sort of would make plea that we actually try and put in place the right disclosures and the right, and I do think disclosures have to be somewhat different because income-based tools are different for the same laws, I think would confuse students more than illuminate the nature of what's happening with ISAs. There's other examples applying existing credit reporting standard income-based tools in terms of things happening. For bankruptcy, the concerns about opening up any discussion about changes to the existing regulatory framework. But I would also make the point that the existing regulatory framework doesn't provide key guardrails in existing for any related to key elements of existing or for income-based products. And I really believe they're necessary to make sure that this works well. And I do believe it's possible working together to come up with something that is both consistent in its application of existing laws and is better than existing law.
Joanna, I briefly saw your hand raised.
Yeah, I was going to say, if you wanted to move on to another question, that's also fine. But I would just say briefly, Kevin was cutting out a bit, so I'm not sure I heard all of that. I did just want to, what brings to mind for me, I'm certainly not going to be the person on this panel in the position of saying we shouldn't add additional requirements here. But I will say that, and maybe we'll get to this in some of the upcoming questions and conversation, that the laws that Brian and I consider sort of the threshold applicability for are quite powerful. And in particular, I mean, we talked a lot about disclosures already, and we touched on ACOA. The Consumer Financial Protection Act that creates the CFPB's authority to address unfair, deceptive, and abusive acts and practices is significant. And so, and the CFPB, building on the FTC's framework over the years, has built out law that does provide regulatory clarity about what UDAP means and how it's used. And I think that the unfairness and abusiveness authority that the Bureau has and that states can use through the CFPB giving authority to state AGs to bring claims under the Dodd-Frank Act would allow potentially, and facts are going to be very relevant in this, but would allow regulators to look at practices that are going to cause substantial harm to consumers that they can't avoid. That's what unfairness is. That are going to cause them to reasonably rely on the things that are going to be to their detriment. So I think that it's important to recognize that we may want to and should be having the conversations Kevin talks about to improve and build on law to provide additional protections. But like I said, I worry that results in narrowing, not broadening. And I do think that the protections that are in place are not insubstantial and could really get at the things that are harming consumers. That's what they're made for, and that's what they've been used for at the CFPB for the past decade, and as of yesterday, and at the FTC for unfairness and deception before that.
Okay, I think we can move to our second question, which kind of looks at, I'm hoping, what we already have in the market at this stage. Are our ISAs, as we see them in practice today, meeting the promises of what we hear so often? Are they designed, or are they being designed in the best interest of students? Julie.
Well, I would say I often go back to the back-a-boiler model because it is the biggest, one of the biggest and most noticeable ISA programs. And I would say that it's not being shaped in the best interest of students from what we know about it, and it's certainly not living up to its marketing. I know there have been complaints about the particular marketing of the way that they talk about it in comparison to loan products, but even just the idea that it's sort of like that you have some kind of protection where, like, don't worry about it if you don't make enough money, you don't pay, feels to me like a deception in and of itself, given that there is no real income protection besides the $20,000 income cutoff. And I bring it up particularly because, ISAs are often compared to income-based repayment programs, but many of them that function like the backup boiler one are very different in that income-based repayment or income-driven repayment plans protect a portion of your income, and then you make payments on a percentage of your income above that threshold. Whereas, as I like to talk about this one on Twitter a lot, because it really does bother me that you have this cutoff where it's like, if you make less than $20,000, you make no payment, but if you make $24,000, you pay a full percentage of your income at that point, which is, I think, not particularly for college students who may not have had to deal with some kind of like lending arrangement or handle their own finances, may not be apparent to them just how difficult that's going to be. It's probably not apparent to them how that will fit in with their other debt obligations. The other, I know this is like always a little bit in the weeds, but the other terms in these loans around default, around overpayment and underpayment are really, really important to borrowers. They don't get a lot of attention, and they either are not well fleshed out in the contracts that we've seen, or they're fleshed out in ways that benefit the lender rather than the consumer. So, like, for example, one of them says, like, in the event of underpayment, the lender gets to determine how you make up for the difference, right? Whether it adds to your monthly payment just gets a little bit bigger, whether they ask for it in a lump sum, whether they extend the term of your contract. But the lender also gets to decide in the event of overpayment. So if the lender makes a mistake and you overpay, they still get to determine whether you get that money back right away, whether it comes back in like little drips over time. Those things are really important to borrowers. What happens in default is really important to borrowers. And I think one of the things that's most troubling to me is when you talk to the schools that are offering ISAs, they seem to have bought into the marketing that, like, no one defaults, right? So they haven't really given a lot of time and energy to these kinds of terms, and we don't really have much to show for what happens on the back end. I think it's pretty worrisome.
I will move on to a question that I'm hoping is particularly pertinent given what we're facing right now. I mean, in the times of coronavirus, it seems like there continues to be some level of interest in ISAs, and as schools and states slash their budgets, ISAs have already kind of marketed themselves as an enrollment management solution. What does this mean for borrowers of ISAs, especially if investors are hesitant to bolster growth?
I'll jump in, Danielle. I think the way to think about this question is that the impacts of COVID are obviously terrible. They're terrible on state budgets. They're terrible on family budgets. And so, and at the same time, we know that a college degree is going to be one of the strongest protectors of students going through a very difficult. So the way with our students is that we want to help them succeed in any way possible. And just as federal loans, for example, are a financing tool to help students succeed and that provide the right protections, I think designed in the right way, ISAs can also be a tool to help students weather difficult times in terms of financial aid caps, if, again, done with the right protections in place. And so this draws everything back, I think, to how they're done, and the question of ISAs being good, or that there are good ISAs and there are bad ISAs. And I think, to Julie's point, she rightly highlights that there's a lot of technical questions about how to do these things right. There's questions about what are the proper ways to document income? What happens if students fail to document income? What can you do in the event of default? What are the appropriate limitations around affordability? And Joanna, you're right that there are broad sort of UDAP protections in law, but my fear is that absent both guardrails and clarity, that people don't, I mean, of course, like if you're trying to do this the right way, but it's very helpful to get actual clarity in law about how to do these things the right way. And I actually think people would benefit from conversations with you guys and others about developing the right things, both for best practices, but also again in law, to provide sort of clear standards for how to do these things. And so again, my basic answer is I think that they can be an extremely helpful tool for students who need them, regardless of the circumstances, but they have to be done well. And I think we need to put stronger protections in place than what's in there now.
True.
Josh, did you want to say something, or I wasn't sure if not, I'll go.
I was just going to say, can you hear me? Yeah. My comment's like 1 minute, and then I'll be done. But I'll just say, watching TV last night, I was very surprised at how many coronavirus-related commercials there were. And it's because coronavirus is top of mind for everyone. And so obviously, if I have a financial incentive to sell my product, I'm going to try to find some way to tie it to coronavirus. And if I am an investor or funder or looking to advance ISAs, of course I'm going to tie it to coronavirus. That does not mean that there's actually a role for ISAs in responding to the pandemic.
I was just going to say, schools are really struggling. Colleges are really struggling right now. So it seems, almost predictable that they would turn to ISAs and every other way that they could get students to give them money right now, because that's what they need to survive, which is really a policy failure, right? That we haven't, in so many ways, the government has not done what it needs to do to keep us, to keep the economy going right now. But my other thought here is like, the pandemic is so different from other economic crises that we've had, and there's so many different things happening right now that it's easy to treat it as unique, but it really, to me, keeps taking me back to 2007, 2008 in many ways. Even though the government has responded slightly differently and better in some ways than we did last time around, we're fundamentally in a similar situation where people's incomes are lower. There's huge unemployment, and we haven't provided assistance to colleges. We haven't provided the assistance to states that would allow them to maintain their investments in colleges. And so it seems predictable that we're going to see the same thing happen. If we don't intervene, then we're going to see the same thing happen that we did last time around, where, student debt was I think it was like 770 billion in 2009, and here we are at 1.6 trillion. And that is not unrelated to our response to the last recession, right? And so I look at what's happening with ISAs right now and see it as part of this larger problem of indebtedness that we're going to see grow in the same way that it did last time around. And we're also going to see the same problem that we did last time around, and that we do in almost every recession, where when people do return to work, they return to work at lower earnings. So we're setting ourselves up for a similar situation. And in spending our time trying to shape different credit products is probably a worthy use of time at some point. But right now, it feels like we ought to be spending our time trying to figure out how to backstop states and local governments so that they can continue to invest in their college systems, to make college more affordable so that people don't have to take on debt, and to ensure that people are coming back to are returning to work at the same or higher earnings, so that we don't end up with a repeat of the last time around.
Okay. no follow-up on that one, so I will move to the next question. So it seems like there's general agreement, at least among the panelists, that there is a framework for companies offering ISAs to follow. Josh, how do you approach that in your work when it seems like most of the action and energy is around legislation that purportedly seeks to create a new framework?
Can you still hear me? It says I'm muted.
Now we can hear you. We did not hear, unfortunately, we didn't hear from the beginning of your answer until now. I'm sorry, if you wouldn't mind repeating.
Oh, no. Okay.
I'm sure it was brilliant. Brilliant.
You missed the most brilliant explanation I could have ever provided.
Did you see Kevin's eyes roll there?
Yeah, I'll try to summarize it in like 30 seconds since I know I've been talking for a long time on mute, and I apologize for that. But we've been thinking about this for a long time, and the question of what are the types of frameworks, what are the types of guardrails, what are the types of protections that we would identify as useful and helpful in any legislation around income share agreements. I think the eternal challenge we found with that is what I was saying earlier, because every time you come up with a guardrail to constrain the worst actors and constrain the contracts that might be the most predatory for students, you start to cut into the profit incentive, the profit of someone, that we end up in a situation where it is very, very, very hard for us to for there to be agreement between consumer advocates and folks like Senator Warren and folks who are looking to make money off of these products, because the types of guardrails that we would erect would result in contracts that aren't very profitable and just don't make a whole lot of money for people, and that sort of removes the incentive for the investors to even have federal legislation. And so I think that's a tension and a challenge that I'm not sure that we figured out how to resolve.
Danielle, I wanted to jump in if it's okay.
Please do.
Just to say, those are all good points, Josh, and you and I have always talked a lot on these questions, and I'd love to keep that conversation going, because I think there's ways to build in strong consumer protections that are flexible and built for the nature of income-based obligations, and think it's worth discussing more. And Danielle, to your point, I since you mentioned sort of there's this broad agreement about that ISA providers have an existing framework to follow. I just want to make it clear that I believe the existing framework should be applied, but there are key ways in which the existing framework is extremely problematic for ISA programs, one being disclosure, one being the taxation that students would face, one being bankruptcy, one being credit reporting, such that that alone would require some adaptations that I think would actually be necessary to achieve the same protections in the existing framework that was sort of the spirit of the original passage of those laws. And then again, adding more things because existing law again doesn't create the correct guardrails, and so people doing these now can create those profit opportunities outside of, I mean, of course, as you're saying, Joanna, there's things like UDAP, but UDAP is a bit more of a vague statute, and so there's opportunities for abuse that I think we would really be well served to foreclose. And I think the paper was interesting in its highlighting of, it draws out a few examples right now of supposed sort of income-based repayment sort of thriving in this space. One being Sallie Mae, and just sort of referencing comments that Sallie Mae made, saying that they would sort of help borrowers in hardship, but without making any sort of explicit commitments around income-driven repayment. One is a private lender advertising IBR, but when you sort of look under the hood, it's IBR only for 36 months with a minimum payment of $50 and with no forgiveness. And so in my book, that's not IBR. That is a mislabeled IBR that is something closer to a forbearance. And then you have other applications of sort of income-based payments in existing law that do things that are much more unconventional in my mind about using sort of the income of co-signers to count towards the income-based obligation, which I think is better than a standard repayment plan, but definitely different. And I say all this to highlight the fact that the current law allows a lot of things. And I think students would be really well served by a much more constructive role for the private market to play, including philanthropy. I think there's ways to use ISAs to harness impact and philanthropic assets in more sort of sustainable and scalable ways. But I think the guardrails are really critical for doing that.
If there is no follow-up, I will move on to another question. I want to bring Jessica back into the conversation. Jessica, Brian, and Joanna, you all come from law enforcement and or regulatory background. In your work, what has been the most striking thing you found looking into ISAs?
So I'll go ahead and go first because we have looked into them. And though we might not have publicized our efforts on ISAs, Iowa has taken action on some ISAs. We've written some informal advisory opinions on folks who were attempting to conduct ISAs in Iowa. And I think what I've seen that's most striking is not necessarily in Iowa, so I don't want people to take it back, but that I have seen offered out there. And I think it gets to what others have said about some of the repayment provisions, and perhaps these are where some of the guardrails need to go if we're talking about legislative specifics. Because like I've said, I think we need we have existing law that helps consumers be able to compare apples to apples and understand the cost of and what they're incurring. But what I don't think we maybe have is some of these repayment provisions, such as, you've got this $20,000, floor, and then you don't have to pay. But after you hit that, then a percentage of your income is due, and you're earning so little, and you're out there on your own, and you're trying to get your first apartment. And we've seen consumers, or I've seen those terms really strangle consumers, and make them, they're back at living at home just to do that. And their fear is that they're never gonna see their full paycheck again, and they feel trapped. So I think some of those repayment provisions have really struck me as potentially unfair, even under a UDAP analysis.
Jessica, I agree wholeheartedly, and in particular, something that struck me as particularly extreme when I was looking at some of these contracts is the default provisions. So there's a payment maximum in most, maybe all ISAs. And I found that in a lot of the contracts, it says that if you default, you have to pay the payment maximum. It accelerates your obligation, but it's not just the amount you borrowed or the amount that you would have had to repay for the period of time that you've had an ISA, it requires you to pay the full amount that you would pay if you reach the payment maximum, which can be 200, 300% of the original amount you borrowed. And so if a person defaults after a year on a $10,000 ISA, they might owe, $30,000. And that, it's a pretty extreme term. And that really struck me as a former enforcer, as something needing attention.
Yeah, I'll just add that I think those are features of what we've seen in our work that have struck me as well. I don't really have anything to add on what Brian and Jessica have said. I will say that I have been struck by how much of this, and our thinking about the paper, it sort of feels like the same exercise I did for 7 years at CFPB, and in sort of just kind of going through the, looking at what's happening to consumers and applying a set of laws to see, where they might be helpful. And so the sort of, what I knew about ISAs coming into this effort was that they were something new and different, and they have not felt like something new and different to me in this conversation. Like, as I, did the work, I would be, and not to say that, that's not a value judgment on the product, though I may have such a judgment, but that's not what I'm saying here. More just that, consumer financial products are wide and varied, and that hasn't posed a problem for, enforcers trying to protect consumers to date. So that's my impressions.
Julie, I saw your hand up.
Oh, I was just going to add to what Brian said, that it's remarkable too that not only that the payment cap kicks in default, but that default can be triggered by not submitting paperwork. So it's not just like you didn't make your payments. It's a pretty big concern here.
Yeah, and we've seen with the way that the IDR program has been administered for federal loans, that defaults for people who are on IDRs, they happen. I mean, they're not uncommon. There are a lot of people who are on IDR who default, and so this is a real concern.
Great. I want to thank all the panelists and our moderator for joining today's conversation. This was a great kickoff to our conference series. I also want to thank everyone who joined remotely watching. Thanks for bearing with us at the beginning, and we're glad you stuck around. Please, next week, July 30th, we are going to have the next round of our conference series. We'll be sending out more information related to it, but please tune back in. And we look forward to seeing you then. Thank you all very much for joining, and now we're going to end the broadcast.
Thank you.